Good afternoon, and welcome everyone to the public review of the Northwest Territories Human Rights Commission Annual Report. Committee, we have an agenda before us. We have one item on the agenda, and that is the review. Can I have a mover to adopt the agenda? Moved by Mr. Natalie, second. Second by Mr. O'Reilly. All in favor? All opposed? The agenda is adopted. So we shall begin. It is the mandate of the Standing Committee on Government Operations to review the annual reports of statutory officers who report to the Legislative Assembly. There are copies of the Human Rights Commission annual report on the side table for any one member of the public who would like to view it. In response to the committee's review of the annual report, we will be producing our own report, which includes recommendations to the government. That report will be tabled in the House in the upcoming sitting. Now, before we commence, I would like to ask the members to introduce themselves, starting on my left with Mr. Thompson.
Good afternoon, Shane Thompson, Nahende.
Good afternoon, Michael Nunley, MLA for Detchel.
Kevin O'Reilly, Frame Lake.
Thank you, and I am R.J. Simpson. I'm the Deputy Chair of the Standing Committee on Government Operations, and with me is Committee Clerk Jennifer Franki-Smith and Legislative Advisor April Taylor. So without further delay, I would like to turn the floor over to the Chair of the Human Rights Commission, Mr. Charles Dent, Director of the Human Rights Commission, Ms. Deborah McLeod, and Chair of the Human Rights Adjudication Panel, Mr. Sheldon Toner. And I believe Mr. Dent will be taking the lead. Mr. Dent.
Thank you, Mr. Chairman. I have some opening comments, and then Mr. Toner has some opening comments as well. So thank you for the invitation to appear today as you review the NWT Human Rights Commission's annual report for 2017-18. Before we get started, I'd like to acknowledge that the Commission works in the traditional territories of the Dene, Inuit, and Métis people, and we recognize our obligations under Treaty 8 and 11. In 2017-18, the Commission continued to work towards implementing a more restorative approach in all of our work, including our complaint process and how we engage the community. The Commission believes this approach will result in a more fair and effective system that will encourage a culture that values and promotes equality. The Director tells me that we're beginning to see very positive results from the shift to a restorative approach. As a more restorative approach in the early complaint process is implemented, more people are choosing to sit down together to try and work out their human rights issues. This year, almost half of the complaint files closed by the Director were resolved by the parties through alternate dispute resolution. In 2017-18, we attended 11 community events, including the Dene National Assembly and the Territorial Anti-Poverty Roundtable. The Commission brought an expert in restorative practice to the NWTTA's 2018 Educators Conference to address plenary sessions and provide workshops on restorative practices. This expert also provided 2 days of training to all members of the human rights system, as well as members from a number of community organizations. The Commission's celebration of International Human Rights Day in 2017 focused on reconciliation and what ordinary people can do to foster reconciliation. Attendees at the event were invited to commit to an act of reconciliation. Recognizing the importance of language to human rights and reconciliation and to make human rights information more accessible to everyone in the Northwest Territories, the Commission has had the Pocket Guide to Human Rights in the NWT translated into all 11 official languages of the NWT. And by the way, we brought copies of all of them except North Slavey, because all of our copies of North Slavey are with the Deputy Chair right now in the North Slave region, North Slavey language-speaking region, where he's using them. So we have we have almost all of the languages available today if you'd like to see them. We'll be pleased to answer any questions you may have about the annual report.
Thank you. Mr. Tony, you have opening remarks? Please proceed.
Thank you, Mr. Chair. Thank you for the opportunity to address the committee and respond to any questions the committee may have regarding the panel's portion of the Human Rights Commission's annual report from 2017-2018. As you are no doubt aware, the panel consists of adjudicators who exercise the independent decision-making role within the human rights system. Each case that comes before an adjudicator must be decided independently on its merits, consistent with procedural fairness and the law of human rights. The panel has worked with the Commission and the Director's Office in implementing a more restorative approach in all our work, and adjudicators have received some training in restorative approaches, with more to come. We will be doing more in anticipation of the new legislation expected to be passed this year. In addition, adjudicators have also adopted active adjudication techniques to assist self-represented parties navigating through the hearing process, which can be complex and intimidating if you're not a lawyer. In terms of numbers, the Human Rights Adjudication Panel has a current caseload of 17 open files being handled by 5 adjudicators. The panel has issued approximately 7 decisions this fiscal year, which already exceeds the number we issued back in 2017, 2018. In addition, parties have resolved a number of other files through settlement or adjudicator-led mediation. We have around 5 of those resolutions so far this fiscal year. So I expect we will see our caseload reduced to around 14 or 15 by the end of the fiscal year, subject to any new complaints coming in, since we have more hearings and mediations scheduled. If you look at the annual report from last year, you will see that we started the year with 31 files. So this year has been a very active one in terms of bringing files to conclusion, including ones that have been in our system for some time. This will allow us to devote some time going forward in preparing our adjudicators for the legislative changes we look forward to implementing in the coming year. Thank you.
Thank you very much. And this is an interesting year because we do have an act to amend the Human Rights Act with some significant changes. So I will open up the floor to questions from the committee. Do we have any comments or questions from any committee members? Mr. O'Reilly?
Thanks, Mr. Chair. It looks like from your annual report that a number of the complaints have come from what are called remote camps. And I'm just wondering if you can tell us, is that basically the diamond mine sites, and are these related to labor relations sorts of matters, or any sort of trends that you might be able to help us understand? Thanks.
Thank you. Who would like to take this? Ms. McLeod?
Thank you for the question. Remote camps could be those kinds of camps, as you mentioned. And I don't think that there's any particular trend. That wouldn't also, we would receive more calls than that, and if those calls are strictly labor relations issues, we would not, we would assist people as we could, and but not, they would not initiate a complaint. Because our numbers are so small, it's difficult in those kind of numbers to see particular trends. It's one of our one of the problems when you have only a few complaints. Thank you.
Thank you. Mr. O'Reilly?
Thanks. No trends, but then, so what are usually the grounds for discrimination that the complaints are based on from remote camps? You know, and I'm not looking for an exhaustive statistical list, just some sort of understanding of what the main issues might be and how we could work to better deal with those issues in remote camps. Thanks.
Thank you. Ms. McLeod?
Consistent with other employment complaints, many of those complaints would be disagreements about the accommodation of disabilities. Perhaps, we would expect that could show up as disagreements about drug testing, things like that. But that would be consistent with employment being our largest numbers of initiated complaints being on employment, and the largest number of complaints having an element of disability.
Thank you. Mr. O'Reilly?
Thanks. I have some other questions, but I'll pass on to my colleagues. Thanks.
Thank you. Anything, Mr. Thompson?
Sorry, I just have one quick one, and I apologize if you already answered this previously. Have we seen an increase compared to last year to this year's report? Thank you, Mr. Complaint, sorry.
Thank you, Mr. Thompson. Ms. McLeod?
Thank you. Let's see here. So in 2016-17, we had 41 complaints. And this last year, we had 39, so that would be, that would be in the same range. Our complaints often fluctuate. Our lowest year ever would have been in, let's see here, in 2012-13, which there was 15 complaints. That would be a very low year. Our highest year would have been 47. So what we're seeing is, I would say, overall, a slow rise of complaints. Even though in 15-16 there were 19 complaints, the 2 years before that there were 30. So there seems to be this slight trend to more complaints.
Thank you. Anything further, Mr. Thompson?
Yeah, just one quick follow-up, I believe so. And I thank you very much for that information. So does this commission actually have, some training tools for, businesses, and so people are aware of that, so, they're more aware of the situation so that they can deal with it before there's complaints? Do you guys have a package that you give to companies and stuff like that? Thank you, Mr. Chair.
Thank you. Ms. McLeod?
So we have an information line, our line to our office, and that line is for people who feel that they've been discriminated against, but it's also for prospective respondents, whether they're employers or landlords, to talk to a human rights officer and ask them for information about what their responsibilities are under the Act. So we support businesses that way. We also have materials developed for those groups, employers or landlords, that are guidelines about the Act. And the Commission has been working on developing policies that will also provide some supports in that way to employers. People call us and ask specifically for us to go and do workshops and information sessions, and we will provide that as well.
Mr. Dent, would you like to add something?
Yeah, if I can just add to that, the commission itself, as part of its outreach program, doesn't just focus on individuals who might have been or feel that they've been wronged. We focus as well on trying to reach employers. Part of the whole process of the purpose of the commission is education and outreach. So we try and target as broad a field as possible. So like when we're at a trade show, or if we're part of a wellness visit to a community, we'll make sure that we go out and reach out to employers as well.
Thank you, Mr. Thompson.
Just one.
Yeah.
Thank you, Mr. Simpson, and that's great news. I'm excited about that. You guys are being very proactive, which is what we should be doing, right? So we can see less complaints, and people are treated with dignity and respect throughout the process. I guess my last question, I hope anyway, is in regards to this material and that. Do you guys have a website, an access that you can share? And are you willing, if you do have one, if you're willing to share with us as MLA, so that we can actually be an advocate for you guys as well to get that information out there? Thank you, Mr. Chair.
Thank you, Mr. Dent.
Thanks. And actually, we would hope that that you would take a look at our Facebook page in particular and share that, because that's what we use. It's one of our best tools for reaching out to the smaller communities. We've got very big reach in our Facebook page. In fact, only Ontario, Quebec, and Canada have more followers than we have. Good number in the smaller communities too. So anything you can do to share our our Facebook page would help to get that message out there. So we would appreciate it if you would like and follow our page and retweet, not retweet, but share it. Yeah.
Thank you. Anything further? Nothing further from Mr. Thompson. I can attest that you have a good Facebook page. There's a diverse array of information that you put out. It's not just stuff regarding the organization specifically. There's often articles about discrimination in general and some interest pieces. You talked a bit about the community events that you participate in. You go out, and I see in the report there's people will attend the Canada Day and do sort of a meet and greet. What's the response, or what are the interactions like with the public at these events? What sort of information is being requested? And I'll just start with that. Mr. Dent?
Well, we take out our brochures, and particularly the pocket guides are the most popular item that we distribute. But we also have giveaways that are aimed at kids, coloring books, crayons, and magazines for young adults or younger children. And that's a way for us to open up the door to a conversation, usually with them and their parents, about everything from bullying to more detailed human rights issues. So it's not, I don't think we could say that there's sort of one area that we get a focus on. We get people coming in, they stop to take a look at what we have to give away, or they stop particularly at Canada Day and on June 21st when we have Bannock. That's a real draw. And it's a good way, people line up for it, and so it's a good way for us to walk among the lineup and talk to people about human rights issues and how they can work to increase awareness in their neighborhood, and make the North a better place.
Thank you. And do you keep stats on how many people are spoken with, or what's handed out at these events? I see there's a list of all the events that have been attended, and I know it might be a little labor intensive to have a clicker every time you talk to someone, but are those kind of stats kept? Mr. Dent? No,
we actually haven't kept that sort of stat. It would be, particularly when we're giving away Bannock, it would be difficult to do because there's typically 3 of us, and it's a very busy time. But we still find time to talk about human rights while we're doing it. Keeping track, we could probably guess at how many pieces of Bannock we get from each one that's cooked, and next time I'll try and keep track of how many we cook and maybe report that number.
That'd be you'd be the only Human Rights Commission reporting that kind of information, I'm sure.
I'm sure.
I have Mr. O'Reilly on the list. Mr. O'Reilly?
Mr. Chair, we had the Information and Privacy Commissioner in yesterday, and we're in the same sort of situation where there's a bill before the House to amend that legislation as well. So one of the questions I had for her, and I'm going to ask of you folks now, is what are the top 2 or 3 things that you would recommend to us or suggest to us in terms of what you want to see in the bill? And I know that you're probably going to come before us during the public hearing in February to talk about this in a little bit more detail, but just to get the committee going on this, what are the top 2 or 3 things that you'd like to see improved in the bill as it stands now? Thanks.
Thank you. Mr. Dent?
From my point of view, I think I'd leave it to Deborah and Sheldon to answer as well, if you'd like to hear from them. I think from my point of view, and yes, Mr. O'Reilly, I am planning to make a public presentation on the bill. I think it's important to remember that this bill really results from the 2015 report that was done in terms of a comprehensive review of the operations of the Commission. From the recommendations that came from that, all 3 agencies agreed with the recommendations, that being the Director's Office, the Commission, and the Adjudication Panel. And we developed what we called a roadmap for implementation, which was tabled in the Legislative Assembly. So I think we're quite satisfied that by and large the Act has followed that process and is a natural successor to the process of the report, the recommendations from not only the report but from the 3 agencies on how to implement. So we see this as a natural progression. Personally, I think the idea that we formalize that we want to have a restorative approach is key to us in the Northwest Territories. The adversarial approach that had developed over years in the human rights process in the Northwest Territories after the Act was first implemented to during its first 10 years of work really wasn't working for people in the North. And a restorative process is much better way of doing things. So formalizing that in the Act, I think, is an important step. It'll make the Act, or make the operation a lot better for people. And I think that's, for me, that's the major part of the whole thing. I guess the second part is that, when I would go and talk to people about how we are 3 agencies, because the Director's Office is completely independent. In the current Act, there's no tie between the Director and either of the other 2 agencies. The Commission is totally independent, and HRAP is totally independent. There's a reason for the independence with HRAP, but I don't think the public, and even and I don't think the Director understood the difference, or why there had to be that wall between the Director's Office and the Commission. So I think that's another important step, to see that disappearing. It'll make it easier for the public to understand that it is the Commission they're dealing with. They've been confused in the past whether it was the Commission or the Director's Office. So I think for me, those are the 2 most important aspects.
Thank you. And did any other witness, would they like to, Mr. Toner?
The question lends itself nicely to the kind of response I can give from the panel, because there are really 3 themes in the bill that are going to affect the panel. One of them is an added provision that clarifies that panel adjudicators can use alternative approaches to traditional adversarial means, and also restorative practices. And our current legislation and rules already give us a great amount of flexibility and arguably allow us to do those things as it stands. But the inclusion of that provision in the legislation will just make it all the clearer and give us tools to do effective adjudication and hopefully encourage parties to achieve early resolution. The second theme is that there's a provision in the bill proposing to expand our powers so that we can include as a remedy anything that might be done to achieve future compliance with human rights, so even things in future practice, and that might include things like looking at training or policy for respondents, where that might really assist them in staying on track with human rights in other cases that come before them. So that's another theme where the changes will affect the panel and give us more tools. And the third one is the commission or director's carriage of complaints. So that's where we're expecting in the final implementation phase of the bill to have the executive director bring the complaints to the panel and carry them, which we take to mean adducing evidence and arguments in the public interest. So that's yet a third tool that will lend itself towards allowing us to achieve human rights results and encourage parties to meet early resolutions.
Thank you very much. Mr. O'Reilly?
Thanks. I have one a really specific question about the proposed changes, and that's looks like the bill contains provisions to take out the penalties that are currently in the Act. So I guess there could still be offenses, but there would be no penalties, which seems a bit odd. Perhaps this is in the vein of a restorative approach, but at the end of the day, you still need to have some backstop, in my view, but for enforcement and to show the gravity of non-compliance with an act. And what's the point of having an offense if there's no penalties? But I'm not sure that, maybe I can ask our guests whether that's something that the Commission had recommended in particular, or if you have any views about removal of the penalty section from the bill, or from the Act. That's what's being proposed in the bill. Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. If we could keep this to the report, because we will have an opportunity in a public forum to discuss the bill, and we'll have an opportunity in camera to discuss the bill with the witnesses as well. So if we could just leave that until those more appropriate times, and we can, and like I said, it's a strange situation because we have a report on the previous way of doing business, and next year we're potentially looking at a different way of doing business. So if you can frame the question in a different manner, perhaps.
All right, I'll try it on the fly. What is in a restorative approach, what's the ultimate backstop here to try to encourage folks to comply up front with legislation. And you know, I understand the role of public education, and you guys do, I think, a good job at that. But what's the ultimate backstop in a restorative system? Thanks, Mr. Chair.
Thank you, Mr. Dent.
I don't think the end result is changed at all of the new act, because if a complaint gets to adjudication, the adjudicator has the power to make orders. And so those orders can include penalties that are financial, as well as now, as Mr. Toner's pointed out, they're going to have broader order-making abilities, in fact, with the new act. The recommendation to get rid of the penalties came from the report in 2015 from the external consultants, who pointed out that it's not something that's used in other jurisdictions, and we don't have the system set up to actually do the enforcement. So we don't have a police system set up that we can use those penalties in any case. So they pointed out that the approach in the current act is not consistent with a restorative approach, and they pointed out that we don't use them, that we're not set up to use them, and likely wouldn't be funded to set ourselves up to use them. So there's not much point in having that sort of terminology in the act anymore.
Thank you, Mr. O'Reilly.
Thanks.
Nothing further from Mr. O'Reilly. Anything further from committee? I have a question about the length of time it takes from the time someone makes a complaint to the time that a complaint is completely dealt with. I know that the commission has been moving away, or the adjudication panel has been moving away from that adversarial approach, and has been moving towards more mediation and restorative justice approaches. And so if someone, I presume Mr. Toner could comment on the length of time it takes to get through a complaint, and whether or not the more recent approach of mediation and restorative justice has had an effect on that time. Who would like to answer that?
I can't really speak to the amount of
Mr.
time.
Toner.
I can't really speak to the amount of time a complaint takes to go through the director's part of the process. But I can certainly speak to what happens once it reaches the adjudication panel. So if you're interested in hearing both aspects of that, the best place to start might be with the director's process.
Thank you, Ms. McLeod.
So right now, I would have, besides things that are held up, because the director can defer a complaint if there's another process going on. If we take those complaints out of because that can go on for years as the parties try and work things out through another process. So I can defer those complaints. There's one complaint that was launched in 2015 that's still active, and 3 from 2016. Everything else is 2017 and later. The length of time depends on the complexity of the complaint. It also can depend on the complexity of the process. For example, if the parties in our present system decide to engage in a mediation process, that could take a matter of months, and if it doesn't settle, then it goes back into the regular process and is investigated and then screened for adjudication. Other delays or length of time can be extended if the parties want to make a lot of submissions back and forth, if they have a lot to say, things like that. I would say that we've had good information that the restorative process will. And if you look at the report that we gave you last year, of the files I closed, almost half of them were settled. And what we saw is, as soon as we started to adopt a restorative approach, which we started in the, I think, early 2018, what we found is just by changing how we approach the parties, we had an increase in the uptake of people who wanted to sit down and try and settle things. So if we go forward and we get that confirmation in the act, in the amended act, I would expect that many more things will be settled early on. And that would overall shorten the length of time that complaints would be taking. Complaints still may not settle then, but part of a restorative approach is trying to help the parties not get positional and understand each other better, which we hope would follow through in the rest of the process. And even the adjudication panel, there they won't be as far apart as they would have been in the present adversarial system.
Thank you, Mr. Toner. You can take over.
So the panel receives complaints in two forms. We receive appeals, and we from directors' decisions to dismiss complaints, and then we receive referrals of complaints. And I'll begin with a lawyer or the answer you would expect from an adjudicator with training as a lawyer. The length of time it's going to take to process those complaints will depend on the complexity, the number of witnesses, all those things. Where we do mediation, that usually quickens the process, because by the time something comes to us, it's been through the director's process and usually some form of alternative dispute resolution. So if we do a mediation, we usually tee that up right away and can conduct a 1 or 2 day mediation. It either resolves the complaint or doesn't. And I would say with the complaints that have been coming in the last 2 years, that's turnaround time for that has been anywhere from 6 months to a year. If a case goes to a hearing, an appeal hearing can again happen quite quickly, usually within 6 months to a year. If it's a more complex hearing involving witnesses, it can be 1 or 2 years. That's the time it's been taking us. The things that can stretch out the time are things like preliminary motions. So sometimes we have to decide an issue before it goes to a hearing about documents or admissibility or in my case, we had a pre-hearing motion about remote appearances, whether witnesses could attend by telephone or video conference. So we get these kinds of preliminary motions that can extend the time. We can also have our time extended if we lose track of the complainant. Sometimes a party will move and they don't advise us of their change of address, so we lose contact with the party. And then something that can also put files back as if they go to court on judicial review on a preliminary motion or a related issue. So we've seen all these things. For a complaint that has your sort of standard number of issues like that, I'd say 1 or 2 years. We do have a couple cases that are older than that in our docket, but for the new ones coming in, 1 or 2 years is about the norm. And I am encouraging all adjudicators to schedule hearings so that they can be concluded within a year. That's still aspirational, but I think we're making some progress towards it. The last thing that does take time is writing decisions, and decisions have generally taken us anywhere up to 6 months to get out, and that's an area where I think we can do better and issue decisions even on a relatively complex matter within 3 to 4 months.
Thank you for that. Anything further from committee? Mr. O'Reilly?
Thanks, Mr. Chair. Sorry, it's a bean counter question. I did notice in the annual report that there was a relatively small deficit in 2018. I guess at the end of 2017-18, $25,000. And it looks like it was largely related to some professional development, legal expenses, events, those were sort of the 3 main areas, and maybe some increased advertising. Can you just talk a little bit about, and I presume this might have been related to your efforts to try to move to a restorative approach, but maybe you can just confirm that for me. And I don't know how a deficit works for a stat officer. Maybe you can just, if there's, how that gets handled, maybe you can talk a little bit about that as well. Thanks, Mr. Chair.
Thank you. Mr. Dent?
Thank you. Yeah, as Mr. O'Reilly's noted, legal expenses were about $50,000 higher last year than the year prior. They've gone up and down. It really depends on what sorts of cases that we get involved in. The Commission now focuses on systemic issues, and when we see a case that requires the Commission getting involved, it means that we have to hire counsel, or have had to hire counsel in order to move that process forward. So it's really difficult to project exactly what the amounts will be each year for legal services. The other growth area was professional development. That's correct, and yes, that's tied to, as you heard from my opening comments. We have run sessions where the Commission's picked up the cost for all three agencies to get this professional development taking place. And in fact, we're planning another one, won't happen this fiscal year, but next fiscal year, where we will be bringing all of the members of the three agencies together again to try and get that development happening so that we can all be part of this restorative process. With the changes that are happening, the Commission members will become decision makers. So there's some professional development that has to happen for them to actually take that role on. So yes, over the next couple of years, we're going to be spending a bit more on professional development. Now, we could afford the one-year deficit because we actually have an accumulated surplus, and the goal is to we don't give the surplus back, but then if in a year we have $135,000 instead of $87,000 for legal expenses, then we've got the funding there to handle it. The same with the professional development. I mean, it may get to be at some time that we'll use it up, but we're trying to be careful and avoid having to come back to ask for extra funding.
Thank you. Nothing further from Mr. O'Reilly. Last year there was I brought something up when I was just a lowly regular member and not chairing the committee. There was a situation in Hay River where there was a company came in to pour concrete and fix the sidewalks, and they came in at the town's request, and then private businesses also used their services. And in Hay River, every building for some reason is built a foot off the ground, and so that means there's a sidewalk, and then you got to step up a foot to get in the building. And this would have been a great opportunity when they redid these sidewalks for the first time in my lifetime, so at least 40 years, to build it up to the level of the store. And so I recommended that the Commission go and speak with municipalities, do some outreach somehow. And it looks like there has been outreach with Elgant and with the NWT Association of Communities, so that they're aware of these types of opportunities when they arise. So could the witnesses please elaborate on the work that's been done with municipalities in terms of making them aware of human rights issues and the services that the Commission provides? Mr. Dent?
Well, I think the outlook is, to date, we haven't reached out to individual communities a lot. We do make sure, though, through Elgant and through the Association of Communities that they're aware of things like there's a federal program to help with the cost of making modifications to buildings or to sidewalks. So there is a program that we make sure they're aware of, that they could apply to for funding to do that sort of change. We've also in the past recognized a Hay River business for actually putting in a ramp that allowed access, and tried through holding up an example of good practice to spread the word. Whenever we're participating in trade shows, we haven't been able to do anything in a Hay River trade show for the last couple of years, so hopefully if that trade show gets back on track in Hay River, we'd certainly be happy to be there, and that would give us an opportunity to do some outreach in your community too.
Thank you for that answer. In the report, there's mention of an accessibility checklist that Northerners will be able to use when planning public events, and I think that's a great idea. Even holding constituency meetings, I have to consider, is this place accessible, and those type of things. And I think this would help a lot of people. So what's the status of the development of that accessibility checklist? Mr. Dent?
Thanks. We publicly launched it on December 10th, and we've We've done some advertising on it. It's actually, I think the radio ads are this week.
Yes.
So it's on, we're advertising at the radio and on press, as well as on our Facebook page that it's available. You can download it from our website, or we'd be happy to get you a hard copy if you want to give our office a call, and we could send them out by mail or email.
Very good, thank you very much. Throughout the report, I also noticed that the term equality human rights is used, and that's a term a lot of people might not be familiar with. I mean, I know what human rights are, I have an idea what equality is, but could someone please explain what equality human rights are? What's the significance of this term? Mr. Dent?
Provinces and territories are limited in their jurisdiction to what rights they can administer. And so we get our authority from the Canadian Charter of Rights and Freedoms. And, what we're talking about in there are equality rights, and how they're set out in the Charter. So provinces and territories can only deal with those. We don't have the broader jurisdiction for all human rights, like the right to housing, the right to the food, the right to those basic human rights are not areas that our commission is charged with looking after, because it's not something that is set out as being available to the provinces and territories.
Is there an enumerated list of what equality human rights are, or would those be the areas and grounds of the Act? Mr. Dent?
Section 15 of the Canadian Charter of Rights and Freedoms will set that out in fairly good detail. But I think it's the easiest way for you to see what we're responsible for is to take a look at the Act, which sets out the areas and the grounds. So, a complaint has to be in an area and be subject to one of the grounds that's enumerated in the Act. That's all that we have jurisdiction over.
And the report sets those out, and I'm sure the website and your Facebook page probably has links to those as well, and I encourage everyone to look those up. Earlier you mentioned the term, Mr. Toner, I believe, mentioned the term carriage of complaints. That sounds like a technical term that probably has a defined meaning. Could someone please explain what the term carriage of complaints means? Mr. Dent?
Sure. In our current system, a complainant is expected to, once they make their complaint, they have to present the arguments. So if it goes to hearing, they have to present the case in front of an adjudicator. So they'd have to come up with precedent and talk about situations that are the same, that have been found to be discriminatory. In most jurisdictions in Canada, the Commission carries the complaint. In other words, they're responsible, and I think Mr. Toner mentioned this in his comments, for presenting the evidence. So it will become the Commission's job to work in the public interest, because human rights legislation isn't seen as private. It's considered to be public legislation, and what we would do then is look after the public interest by making sure that the cases are brought forward before the adjudication panel.
Thank you very much. Is there anything further from committee? If not, I want to remind the public that the committee will be conducting public meetings on Bill 30, which was mentioned earlier. That's an act to amend the Human Rights Act. We'll be in Fort Smith on Monday, Inuvik on Tuesday, Fort McPherson on Wednesday, and this is next week, so this is right away, and Tuesday, February 5th in Yellowknife. And you can find more detailed information on the Legislative Assembly website. Seeing as there are no further questions from committee, on behalf of the committee, I would like to thank the Chair and Director of the Human Rights Commission and the Chair of the Human Rights Adjudication Panel for joining us today. Committee, we are in recess. Thank you.